Good morning, everyone. I'm Rebecca Daniels. I'm a senior associate in the Planning and Environment team here at K&L Gates. Today, I'm going to speak about some of the provisions in the Housing and Planning Act 2016, which became law on the 12th of May. There was quite a lot of ping pong between the two houses of Parliament before they could agree to this act. And it went back and forth, I think, 6 times in the last couple of weeks of the session, which I think indicates that it contains quite a lot of potentially controversial measures. When the bill was initially published in 2015, the government said that the provisions would kickstart a national crusade to get 1 million homes built by 2020 and transform generation rent into generation buy. Well, in overview, I think the Act's strategic objectives are to increase the delivery of new homes, increase the affordability of home ownership, and I feel the government kind of has a real bee in its bonnet about planning, and it kind of sees it as an obstacle, and I suppose its aim is to remove any unnecessary obstacles that planning poses to this agenda. As mentioned, the Act covers a large number of areas, but I think of greatest interest to us today in terms of unlocking brownfield development are the proposed reforms to the planning system, in particular the permission in principle, the associated Brownfield Register, the process of planning applications, and I thought I'd also mention, given the potentially massive effect they might have, the new starter homes. But the first point I just wanted to mention was, although when a new act is passed, there's a lot of fanfare and excitement, actually this one lacks much of the detail that will actually allow us to understand how all the provisions will work in practice. So we're just going to have to wait and see what secondary legislation says. I mean, the government has actually recently consulted on the changes to the planning and on the provision of starter homes. So I think I've seen a couple of responses to that consultation from various bodies, but the government has yet to respond. So let's get started. Okay, so the Brownfield Register, which we've already had a bit of a discussion about this morning already. So the government's concern is that the information currently available on brownfield land is out of date and incomplete, which means there's no clear view about how much brownfield land is available as suitable for housing or what proportion of sites have planning permission. So the government has pledged to get planning permission in place on 90% of brownfield sites. And I think 73 councils across England have been given £10,000 by the government to pilot these registers. Interestingly, if you actually search brownfield in the Act, the word doesn't appear in it once. There's nowhere there. There is just a provision for a requirement for a register of land to be compiled by a local planning authority, but where the actual type of land and the content of the register are being left to secondary legislation. So as I think Paul mentioned earlier on today, regulation is going to have to be really clear on the definition of brownfield and the qualifying process for the sites which are to be included in the register. So we'll just have to wait and see on that one. And although this register may be useful in and of itself, I think in terms of the Act, it's really just a vehicle for the next thing I want to talk about, which is the permission in principle. So the permission in principle is a new route to obtaining planning permission for certain housing-led schemes, and it will establish the principle of development on a specific site. So the government's view is that the permission in principle will speed up the process, provide added certainty at an earlier stage, and so save applicants money. In its impact assessment report, the government states that 7,000 sites could benefit from this change. So the way I think it's envisaged to work is that it will be two kinds of permissions in principle. The first one is where a site is either designated by the local planning authority in the new Brownfield Register as suitable for housing, or where it's allocated in a local plan or a neighbourhood plan. And in each case, the document must identify that the site has the benefit of permission in principle. So which means that all the plans which already have designations won't suffice. That's not sufficient, so you'd have to have updates. So that's the one thing, one way, the designation. And the second, an alternative way, is where an application can actually be made for a permission in principle. And I think the government's intention is that this one will just actually be limited to minor housing development of fewer than 10 units. The key point to note is, the key point to note is that the permission in principle will not be a planning permission in itself. A subsequent technical details consent will need to be granted. And it's at this technical details stage that the LPA can add conditions, negotiate the planning agreement, and that SIL will apply. So in consultation, DCLG proposes that 3 elements will be covered by the permission in principle: the location, use, and amount of residential development, which means everything else, design, access, layout, landscaping, affordable housing, will all be dealt with at the technical details stage. So I think this gives rise to quite a number of issues. First of all, environmental impact assessment. I think DCLG think this can be dealt with at the permission in principle stage, but I don't see how it can be done unless there's more detail, because you'll need the parameters of the scale of the development, the height, width, length, building, of each building, which I don't think are currently required. So it seems that some form of impact assessment will be needed at the second technical details consent stage to overcome this issue. And I'm also not sure it deals with what the government want to achieve. We already have outline planning permission. We already have designations in local plans. With this process of permission in principle, it seems the permission will not actually be granted until quite late in the day, whereas with actually outline application, although you need more work up front, you would get your principal permission earlier potentially than you would because under permission in principle, because you have to deal with your technical details consent. So I'm not sure what actually it adds to the system we already have. And it also, having a whole new approach, it just increases the workload on local planning authorities even further, really. So I can see the idea of wanting to create certainty earlier on, but I'm not sure permission in principle will necessarily achieve that. The next point I wanted to cover with you is perhaps the most controversial measure, one of the most controversial measures in the Act, and it's the government's intention to open up the planning system to competition. And it's so controversial because it really just cuts across the fundamental principle we have about how we make our decisions about planning. So I think at first it's proposed to just be tested in a few pilot areas. And the important thing to note is that it's not actually the determination of planning applications that will be privatised, it is the processing of those applications. So Brandon Lewis, the Housing Minister, has said, introducing choice for the applicant to shop around for the services that best meet their needs, it will enable innovation in service provision, bringing new resources into the planning system and driving down costs whilst improving performance. The logistics of how the privatisation of planning are going to work will need some sort of serious clarification. Who will carry out the requirement to consult with statutory consultees? Who will prepare the committee report? Who will present to the planning committee? All of these quite complicated issues to see how the actual interrelation between the private entity carrying out the actual processing of the application and the local authority, which still has an involvement. Conflicts of interest may arise as planning consultants often work both sides of the fence. The key for local planning authorities is that decision making will need to be robust, so to avoid judicial review claims. So what happens if an aggrieved party makes a claim? It will be against the local planning authority, not the provider of the private provider of the processing of the planning application. So what would the local planning authority do in that situation? Well, presumably it would have to make a claim against the private provider, but it all would get very messy. The technical consultation makes clear that the government does really envisage a competitive market for processing of application where different providers can set their services standards at different levels. So there could be potentially a gold, fast track service with higher fees. But ultimately, again, because there's still interaction with local planning authorities, I find it sort of hard to see how it will work in practice. And if the concern is that the determination of planning applications is too slow, because perhaps the simplest solution is to increase the capacity of local planning authorities to make the decisions rather than remove it. But I know definitely some developers will think this is a fantastic idea. Potentially, I can see it could improve the turnaround time for granting of permissions. But developers may need to be careful that the decisions themselves are robust, because there's no point getting a planning permission if actually it's wide open to challenge because the procedures haven't been followed correctly. But ultimately, there are always different views on whether privatising any service will improve it for the end users, and I suppose planning will be no different. So we'll just have to wait on this one. Finally, I just wanted to talk to you, the last big area of this Act is starter homes. Starter homes are a new form of affordable housing for first-time buyers between the ages of 23 and 40. These homes, the aim is that they'll be sold at no more than 80% of the local market value, capped at £450,000 in London and £250,000 across the rest of the country. Now, the Act imposes a general duty on local planning authorities to promote the supply of starter homes. And the Secretary of State has been given power to dictate that local planning authorities can only grant permission for residential development where the starter home requirement has been met. But we don't actually know yet what this requirement will be. The consultation indicates that the intention is for starter homes to apply to sites of 10 or more units and for the actual requirement to be 20%. I imagine there will be exemptions on the grounds of viability for certain types of sites and uses. And the Act actually goes even further. It gives the Secretary of State power to issue a compliance direction to local planning authorities that fail to promote starter homes. So again, how is this one going to work? Crucially, the Act doesn't provide clarity as to whether the delivery of 20% starter homes will take precedence over the delivery of other forms of affordable housing. However, I think it's expected that the guidance will confirm that this will be the case. This raises a number of issues because obviously this is a kind of very blunt instrument. Not all areas of the country need 20% starter homes. It seems a very arbitrary figure, when different areas have different needs. And also, what about the other forms of affordable housing that are needed in other areas? And I think we'll have to be careful to see how this works and the balance of the shared ownership and affordable rented tenures as well. And I think this will also lead to more work for local planning authorities, because if the starter homes do take precedence, local plan, affordable housing policies and underpinning viability and planning and housing evidence base will need to be updated to take account of the impact of starter homes. This one, all the difficult stuff has been left to secondary legislation. So your first-time buyer, they buy their house and they buy their starter home, then a few years later they want to leave. So what happens when you resell it? Well, I think the idea there's going to be a taper on the discount of resales. So I think the government's initial plan was for a taper for 5 years. So effectively, if you bought your starter home, kept it for more than 5 years, you could pocket your not only whatever increase, if any, there's been in the market, but that 20% that you had as a discount to start with, which just seems a bit bizarre if the genuine intention is to create more affordable housing. But in this one was heavily debated, and during the debate in the House of Lords, peers supported an amendment to actually make the taper 20 years. but the government has expressed that it won't accept anything beyond 8. So again, we're just going to have to see what happens to this taper. So the question here is, whether it stays affordable for very long. The other question beyond that, one step back, is whether it's ever affordable in the first place. And I think in some areas of the country, particularly London, I think it will be a problem. I actually saw some figures prepared by the London Borough of Hackney, which said if the price of a flat was capped at £450,000, even with a 10% deposit, a household will need an annual income of £115,000 to raise the mortgage necessary, which is well in excess of the median income of the borough, which was £35,000. So questionable is whether it's going to actually be affordable to start with, and whether if you consider it is affordable, whether it will stay affordable for very long. But so, as I said, so much of the starter homes remains to be settled in the secondary legislation. So the government's aim of delivering 200,000 starter homes by 2020, I think is looking very, very unlikely, because local planning authorities still have no idea what they're expected to really do to implement this. So I think that sort of the general theme of my talk is I just wanted to raise these things with you, but really the devil will be in the detail, and we just have to wait and see what the secondary legislation says and the results of the consultations. I think potentially some of the schemes do have, they could offer some help in assisting bringing forward development, but all of them have really significant potential problems, and I can't help but thinking there might be some sort of the government might be pushing a deeper, maybe ideological agenda with some of the changes they've put on the table. But we'll just have to wait and see. So thank you very much.